And today we're very excited to have as our speaker, Jason Lyon, partner at Hahn Hahn, also member of Pasadena City Council and a former board member of us at the partnership. So thank you so much, Jason, for having us.
Thank you.
And thank you.
Thank you all for being here. I really appreciate that you took time out of your schedule in the middle of a work day to come here from the other side of the planet. So welcome to Pasadena. If you read the disclaimer, this may be attorney advertising. We're not promising you any results. You can read it later in your own package. There we go. So again, my name is Jason Lyon. I am a business litigation partner here at Hahn Hahn and also the chair of the litigation department. And the head of the practice group that does business disputes and partnership realignment, which is really the group that we're kind of coming from today. I work primarily in that group with my partner, Kirk Moon, who is a transactional attorney, and Nina Golshan, who is our superstar business associate. So this presentation is really intended for anyone who is partner in a limited partnership, a member of an LLC, a shareholder in a closely held corporation, and also service providers who work with those people. Because what we're going to see as we go through the presentation is that you as service providers, if you are an accountant or an attorney, you are very likely to see some of the issues with the partnership before the partners themselves notice that there's an issue happening. So you are an important partner for us in helping head off problems with partnerships. Hahn Hahn is, in the interest of truth in advertising, 126 years old. He added 25 years to it. We were founded in 1899 by two brothers from the Midwest. We have been in continuous operation since then. Today, we are proudly a majority women business enterprise, but they do let a couple of guys still in the partnership. Thank you. If you have any questions, throw it up a hand, and I'll either try to answer it as we go. There'll be a time for questions at the end. If I'm going to answer the question, I'll tell you that the answer's coming up. Now, if I can just learn how to use my little remote control here, we're good. So with partnership disputes in particular, and can help from the beginning of a partnership, from formation. That's really the time when you want legal counsel, from the time you're thinking about going into business with someone. We can help when the partnership exists, when it hits bumpy times, and if necessary, we can help with dissolution and separation if the partnership needs to end. But in this practice group in particular, with business disputes, there are three scenarios that we see again and again and again that are the sort of setup for later tension in a partnership. The first is friends who go into business together. And this, by far, this is probably the majority of my practice. Two people, often it's a kind of a side hustle from their main work. They decide they're great at flipping houses is a common one. Or they're going to buy some real estate or passive income together. They don't do a lot of thinking up front, typically. They talk about how much money each of them are going to put in the beginning. And then there may or may not be any more formality in the relationship after that. The second setup that we see a lot are professional partnerships. These will be accountancies, medical practice groups. Typically, these come together out of a larger employment entity. So they'll be working together for sort of corporate employment and decide they're going to go out on their own in a small group. These do tend to have more formality at the beginning, but often the formation is with one of the online legal services, which I can't tell you how much we don't recommend. It's better than no documentation at all, but it often creates more issues, particularly if you're using a service that's not particular to California law. And then the third thing we see a lot is succession in a family business. So when we get to the second or third generation, tension starts to show up. There tend to be struggles over who's going to do what. And so this isn't what happens at the beginning. Often we don't see people at this stage of the process. When I see them is 5 years later. So they come in, because they're no longer getting along at all, not speaking as friends, happens a lot. And if there are an equal number of partners in the partnership or directors on the board, often by the time they get to me, they're in complete deadlock. They can't get anything done and they're frozen in time. And particularly in real estate, which is one of the common places where this shows up, that can be deadly. You're talking about carrying costs of properties that you meant to sell. I have a case right now where they got together to flip a bunch of properties. They kind of knew at the beginning what they wanted to do. One of them put in money, the other one was going to do sweat equity, but they never decided how that was going to be valued. And now we are 4 years on from when they meant to sell, and everything's pretty much upside down. We see that a lot. Or if there's not an equal number, or if someone is clearly a majority partner, the other thing I see a lot is a frozen out minority interest. They don't have insight into the company's finances, they're not involved in decision making, then there are no distributions happening, so it's as if they're not an owner at all. And then particularly, this happens in all the businesses, but particularly in family-owned enterprises, as there is a change of generation, there are these tug of wars over who is going to control the company. The worst is when grandparent founded and there are like 3 kids, and then their kids are all trying to figure out, all the cousins are trying to figure out what to do. A lot of tug of war. Sometimes we see the inverse of this, which is where no one really wants to do anything with the company, but they want to make money off it and they don't want to get rid of it. And that's actually easier to solve than if somebody wants to be in charge. And then this is probably the biggest prop that gets people in to talk to me. There's frequently a circumstance where there's one partner or shareholder, director, member, manager who's kind of running things and at some point feels like, this is my company, I put all this work in, I'm entitled to more. And so they start taking a salary, they start taking distributions that others aren't taking, they start charging personal expenses to the company, which may or may not be legitimate in context, but it's never been discussed among the partners. So these are business disputes ultimately, right? But they're not really like any other business dispute. It's not like a breach of contract case where there are liquidated damages in the contract. Somebody's going to pay somebody some money and you're both going to go your separate ways, right? Maybe there's bad feeling, but it's a business thing ultimately. These disputes tend to be much, much more personal. So they're the sort of business equivalent of family law. We sometimes say that I'm a business divorce attorney. And so really what I'm here to encourage you to do is your business prenup before everything gets started. But people in these family businesses and in small things where people start them together, there's obviously the money aspect, but there's a real sense of identity and ownership and then and feeling in the friendships that complicates both the relationship in operating the business and certainly complicates trying to separate the business. Typically, there's a problem of trust breeding informality in the beginning. So we love each other, we're going to do this thing together. We don't have to worry about it. We'll figure it out as we go. Happens a lot. It's really, really much better for your relationship if you figure it out in advance, what it's going to look like. And that informality tends to carry through into running the business. So there are all these operational shortcuts, the things you would see in a more formalized business or in a publicly traded company don't happen. So regular board meetings, year-end financials that go out to everyone, audits, and that all creates complications down the line. And there's this issue often where one person feels, as I already talked about, one person feels like this is my thing, I built this, I'm entitled to more. In that sense, creates a really difficult hurdle for resolving issues. And in general, emotion tends to override reason in these cases. So I think on my bio, it says that my practice is equal parts strategy, storytelling, and psychology. And strategy and storytelling are tools of the trade for every litigator, and to some degree psychology as well, but I don't know that other litigators spend as much time as I do holding my clients' hands and talking them through their feelings, trying to get to a resolution, because people, the resolutions typically are as much about feeling personally vindicated as they are about coming to a business solution. So what we really recommend, again, and no one ever takes the advice, but maybe you will be the exception, is that you think about all this in the beginning and you do that with legal counsel. So if the formation documents have the answers in them for how we deal with various circumstances, it's much easier to deal with those circumstances and to resolve them as they arise. So the things that you want to talk about, and you ideally have counsel asking you these questions, are: how's money coming in? How are we characterizing that money? What happens if there's an expense we need on the fly? How are we characterizing that? And these conversations, you would think they happen, but they really, really don't. But sometimes in a two-person friend business, they each put in $10,000 and then we'll go from there. And it makes it very difficult to figure out what's happening later. Even more difficult is that scenario I talked about a minute ago where one person's giving sweat equity. They never talk about how you're valuing the work, how you're tracking the work, so there's no way to say like, okay, your work was worth $10,000 and yours was a $10,000 capital contribution, we're equal. And that's a pretty easy thing to resolve in the front. The other thing you want are clear governance standards in the operating agreement or the partnership agreement. Who's doing what? Who makes decisions? What decisions need more authority? What decisions can be made by one person on the fly? In the California law, if you're an owner or a shareholder, you have some access to books and records. You're entitled to profit and loss statements, balance sheets at the end of the year. You may want to agree to deeper access than that, to bank statements, for example. All of that, and you think you're entitled. Often people think they're entitled to things they're not really entitled to under the law. So talk about that in advance and figure out who's doing what. And then, yes, yeah.
It would be helpful when you're thinking about what this applies to.
This is Chris Kearns, our managing partner and also a fantastic transactional attorney.
Sorry. When we're talking about real estate, another way to own real estate in a partnership is tenants in common. That happens a lot where family members or friends will come together and own property and they just own an undivided interest in the land. This all applies to that. And I would encourage you to think about it. Well, you might not think I don't need a partnership agreement. We're just going to own it together. Well, we can call it what you will. It could be tenancy in common agreement. It can be a co-ownership agreement. The same concepts apply. So, and that document or that agreement is very important.
Yeah, whole fights over how you took title and you thought you owned one piece, but you really owned something different. Rights of survivorship can complicate all of this. We recommend that your governance documents provide for some independent review of the finances on a regular basis. And ideally, you're doing that on a regular basis anyway. It should cover who's an employee and who's not, how money is coming out of the company into people's hands, when distributions are made. And then annually, you should have true ups of the accounting. This often doesn't happen as well. They're sort of just running the business and no one's thinking about where the money's flowing. Another thing that comes up a lot in these is that, particularly if it's a side hustle, it's often something that's related to the professional work of the partner. So someone is a meat wholesaler. I've had this case. Is a meat wholesaler, and they decide to open a deli together. So they're going to be buying product from the one person's business. But so you have to think about, how's that deal going to get made? Who's going to set the terms of the deal? How are you going to deal with the conflict and make sure that you're getting a fair arm's length transaction? It's frequently, this does not get dealt with. And then dispute resolution clauses are so important. How are you going to handle it if there's a fight? Is it litigation or arbitration? Is there mediation before litigation? Is there other carve outs to speed up some relief if somebody is standing in your way? All of these things, how are you going to decide who's going to decide your dispute? These things are much more easily talked about up front. You get them in there, a dispute comes up, we just go to the document and do what it says. But often they're not. And then so we have a fight about where we're going to do this, who's going to be the neutral, which can take a lot of time. The more things you fight about, the more money it's going to cost at the back end. And then the other really important provision is how do you divest yourself of an interest? What happens if somebody's getting out? Can they sell to someone else? Is there a right of first refusal? What happens if there's a divorce and a spouse? People don't think about this. This just came up in one of our presentations last week. So you're partners with this guy over here, but you don't think about the fact that his wife has a community partner community property interest in the partnership. Suddenly they're divorcing, you got yourself a third partner who doesn't get along with your other part. All of that in advance, you can resolve, but you need someone kind of prompting you to think about it. Then you need to talk amongst yourselves and get it into the governing documents. So that may or may not happen. So if it doesn't happen, or even if it does, when tension starts to come up, the earlier you deal with the issue, the more likely you are to save the partnership in the business, if that's what you want to do. But often in the midst of the work and the flow, people don't notice that they're having issues for a while, which is why I said that service providers often do, because you'll see some of these things come up if you are, for an example, an accountant, you'll hear from people before they do. One of the first signs is that decisions start to take longer. You table things. We agree to disagree. We'll come back. There's a delay in getting stuff done. Or when there's a kind of small group of people, they start happening with a split. So you got the partnership vote is 3-2, where we used to do everything by consensus. The second thing is divergence from the written agreement. And this happens a lot, in part because people don't go back and look at their written agreement. They just do things the way they do it. So one of the things we'll talk about in a second that you want to build in is a regular check on how you're doing, the health of your partnership. But as you move away from the agreed procedures, tension rises. And close to that are things that, even if they're not written down procedures, the things you've normally done start to change. So I had a big real estate dispute between two partners who owned a lot of commercial real estate out in the San Gabriel Valley. And they were both the two directors of the general partner corporation. And the way they had their board meetings, this is not necessarily what we would recommend, but the way they had their board meetings was they would go play a one-on-one game of basketball. And they would talk about everything they were shooting, they were playing, and they would work out what they were going to do, and they would make a decision. We would recommend more formality and definitely some minutes of that basketball game. But the basketball game stopped happening because they weren't liking each other. And consequently, they stopped having board meetings. And so the majority interest started to do what he wanted until he sold a giant piece of property without consulting the other partner, and our lawsuit began. We won. This is the next few things that come up are all sort of related, but they go to how you're feeling about the company and its future. And so the disagreements over reinvestment versus distribution. One person wants to start taking out money, wants to start thinking about a sort of runway, a sunset. The other person's looking to grow and expand. Those tensions signal some ongoing difficulty. And relatedly, the misalignment of what are we doing here? Are we trying to grow this thing, or are we just making a buck and then we're going to go our different way? Quiet erosion of trust is one that partners often don't recognize. in themselves. They slowly have started not to like their friend or their business partner over time. This is one that, as a service provider, as someone working with the partnership, you will notice earlier than almost anyone. And you can, it's a real service to say then, hey, I'm noticing that you're calling me to double check everything that's happening with the company rather than calling your partner. What's going on? Maybe you want to talk to someone. And then relatedly, somebody, if the threats of leaving, talks about how they're gonna wrap this up, start to increase, it's a bad sign. Those are all red flags. We tend to see these things come up it can happen anytime in a partnership, but at real moments of transition in the partnership. So a reorganization, a lot of growth will do it, a lot of money coming in the door will do it. Big transactions, like selling or buying. Addition or loss of a partner, either one can change the whole dynamic in a room. And certainly with family businesses, those moments when you're leading up to or coming out of a generational transition, succession is one of the big fights. So there are sort of two ways to go. The better one is to sort of mindfully manage your relationship. And you do that by working in opportunities to pay attention as you go. So we strongly recommend that you sit down together or with a third party, with your counsel, with your accountant, with all of the above, everybody gets around a table and look at the partnership every year. And that may seem frequent, but a lot changes in a year. Look at the governance, look at the organizing documents and see, are we doing exactly what we said our procedures are? And if not, do we want to amend the procedures or do we want to get in line with the documents? Either one could be appropriate, but make that decision sort of mindfully together. It's also an opportunity for people to raise issues they're having. A minority partner can say, hey, I would love to have a little more information here, in a way that the heat can be taken off a little bit if it's just a regular thing that you do every year. It's also a chance to make sure everyone understands the financial health of the company, which they don't always. Right, this one, I wish we could get small businesses to do, and it happens the least, but document everything. And I think people tend to feel like they're being overly legalistic with their family. They're like, we need to do the minutes and then we need to formally ratify the minutes, but both those things are important if you want a record of the conversation that you had, so that we can come back later together and say, this is what we agreed to, and we later agreed that this document was correct because we adopted them at the next board meeting. Both those things matter. And this is how we decide. Waivers of rights, consent forms, all of that is really important and can be uncomfortable, which again is one of the reasons you want to have that annual checkup with an outside third party, because they can sort of guide you to that and make it less awkward. And then the third thing is using independent accountants and bookkeepers where all partners, members, shareholders have access. I mean, if you have a lot of shareholders, you might not want everyone to have access, but in general, in a really small organization, everyone should have access. This also surprisingly doesn't happen a lot, because the two friends go into business together. One of them has an accountant he's used forever, and I love him. And that's who they use. And then there's a feeling that there's loyalty to that one partner versus the other. Really better if together you pick someone who's a neutral and accountable to everyone. Or there's the hard way, which is litigation. Now, you would think as a litigator, encouraging it, and it is sometimes necessary. It is one of the ways that we resolve problems in our society in a civil way. It often is the right thing, and sometimes litigation is the thing, just the thing that's needed to get everybody to the table to have a conversation. But I tell every client when we sit down to think about filing a lawsuit, that litigation is financially, emotionally, spiritually, and in every other way you can think of, time taxing. It takes a lot out of you. And it particularly is true when there is all this emotion involved. So it's not ideal. Ideally, you will have come and dealt with the problems beforehand. If we're going to file a lawsuit, typically these are the kinds of claims you would see. they tend to suggest wrongdoing on the other person's part, or on my client's part if I'm defending. And you're looking to break up the company forcefully with a judicial order. And then the other side has a chance to buy out your interest, and then you have to value the company. It's a long, slow, and pretty arduous process. But sometimes it's the only way to resolve the dispute. The remedies are dissolution of the whole company. That's an extreme one. You can go to court just to obtain an accounting if you can't get information, and there's even sort of a fast track to get to that. And then the various buyout procedures that are available. Sometimes you can seek to partition the assets depending what they are and how you own them. Or sometimes you can seek a receivership, which is where someone else is running the company for you. That only works if the company is very, very valuable, because it's incredibly expensive to have a receiver, but sometimes it is the way to go to clean things up and to find out who's been doing what. Discovery in these cases is hard, which makes the cases more expensive. The fact that you've been doing everything informally over the years, and the best documentation we have is now in the age of email. At least maybe there was a text or an email back and forth that suggested what everyone agreed to do at some point. But we fight over access to QuickBooks. Often in these kind of partnerships, one person is the money person, and now they won't let anybody see what they've been doing. I have that case right now. And typically, you're not doing GAAP accounting for a company of this size, right? It doesn't make any sense. But the lack of that formality and that rigor can make it very, very difficult to figure out what's happened with the money. And so then we look at a forensic accounting, or we look at having an accountant reconstruct everything that's happened for, say, the last 5 years, which is incredibly costly. And then there can be attorney-client privilege issues, which we won't go into now, but that if you've shared an attorney, that attorney typically is out of the picture because you both have shared confidences. So you both got to get new counsel in this fight. And then the big fight typically is over what the interests are, what the interests are. And so how you're going to value goodwill. How is there going to be a minority discount? This is the big fight. And if you did any salary normalization, that notion that someone was taking a salary either as their distribution or for extra work that the other person did, and how you value that in the economics of the company is typically where the fight lives. But the biggest challenge of all is the thing I talked about, which is the big feelings. And so it can make a rational business-based resolution very hard to achieve. And so the cases where people are really happy are the ones where we figured out something where they felt like they got some emotional something without getting revenge or total retribution, but also got some money. And those can be hard to achieve, but typically that's where the resolution really lives. So the one takeaway here, though, of all of this, and I think it's probably clear now, the time to negotiate peace is before the war. And the earlier the better, but it's never too late. So if your partnership is going great, you're getting along, and you're still completely informal, now's the time to formalize your relationship. If the partnership's not going that well, and you're not getting along, now's the time to formalize your relationship, and it may be the time to think about separating. Carl.
Other than cost, and you make some very good points, how do you convince someone? Because a lot of times you get clients that come in and they've got a great deal, they're going to start a business, they're all excited, we're ready to go, and they say, we just got to get moving on this one. And you say, well, you got to negotiate, you got all these terms, we got to think about all these other things. How do you overcome that hesitancy? Because they say, well, I want to spend the money on developing the business. I don't want to spend a bunch of lawyer fees.
They don't. Yeah.
So what techniques have you seen or
I mean,
suggest?
We do a lot of presentations like this just to sort of let people see what happens at the other end, really. But this happens all the time, right? You have limited resources, you're trying to buy a house. And you're gonna spend $5,000 on a partnership agreement, maybe not. But that is an investment in your later relationship and in your financial success. That's the thing I would say. The reality is that what we often see is that people go on one of the online resources, they download something, they use that. And again, that's better than nothing because it gives us a place to start. It just usually doesn't cover what we need it to cover. Any other questions? Yes, sir.
Thank you for calling, sir.
It's the southern boy in me, I can't resist it.
In your practice and in your experience, have you found a overflow of issues stemming from internal conflicts within the partnership or the business? For example, extending out to customers of the business or vendors of the business. And I would expect so, because there's a problem internally, it's got to leak out into other aspects of that business's relationships with people. Then the question then is, it actually, I think it exacerbates, or does it exacerbate the problems within the partner, within the business, when it's particularly, as you pointed out several times, there's very little, if any, documentation to protect the owners from attacks from outside.
Yeah, so third parties show up in a few ways. Dean is a bankruptcy attorney. So their debt issues and the third party creditors, worse if one of the partners doesn't know about it. Even worse if they're not liability protections built into the organizational structure. And so the partners are liable for something they didn't even know about. So that's one of the ways third parties show up. The other way that happens with some regularity is some collusion with third parties in some way. So the partners are not getting along, and so they have some side deal going with someone, or they're trying to roll into a different business with someone. That shows up for me somewhat regularly. They're trying to take the sort of goodwill and client list from this company and start something new over here. So then you end up with that party comes in as a defendant, and you've got an interference with economic advantage claim. And then the tensions that go along with the relationship that show up in the other relationships, but legally those are probably the two ways: creditors and people who are somehow participating in the wrongdoing.
How common is it, like, so let's say somebody does it correctly, they come to you at the beginning of the process, that as you're going through this and kind of identifying all these things, that they just kind of realize there's two completely different approaches, two completely different philosophies, and they just like say, you know what, forget it, we're not doing it.
So this is actually for transactional attorneys, because I'm a litigator, so I see them when it's all gone to trouble. So how often do people come in to start a partnership and then decide like, well, this is too much trouble, or I'm gonna do this on my own?
I've had it happen twice in 5 years. Once at the startup phase where they just realized they weren't on the same page in terms of the business plan or anything and just decided to walk away. The other was a family owned business, owned a piece of real property, and succession planning had gotten it all the way down to the kids, and they wanted to restate everything, got about halfway through, realized that they were just on completely different pages and walked away with a document in tatters. So yeah, not an ideal outcome on the second one. That was after they'd already run up quite a bill figuring out that, hey, this document that governs our partnership doesn't say what we thought it said. How do we rework it? And they had no idea. And now you're already in business together and you own something together and you can't have language that says that.
I mean, it's such a better outcome than that, right? 5 years of just slowly devolving relationship. Jim, you were gonna say?
I was gonna answer it differently than Kirk. I was gonna say it happens about as often as a couple that comes in for premarital counseling. Lucky. Kirk has been lucky and been able to convince clients who shouldn't be together, not to get together.
Yeah.
We have a pretty broad practice here. We have family law lawyers, and a couple of them gave a program a few months ago on premarital agreements. And I thought was very apropos here. when the clients or the potential partners get together and say, well, we want to do this, why should we pay a lawyer? Their answer on the premarital side was, you have, a plan for how to distribute and devise your assets. It's what the state of California imposes on you. So if you're going into business together, the state of California has rules and laws that will apply to your venture. And you might not know what they are, but they exist.
Yep.
So you have a plan, you have an opportunity to change that plan and to make it what you want it to be. And I would say to those partners who would prefer just to get in and work things out later, to let them know, nobody gets into marriage with the idea that it's not gonna last, right? Nobody gets into business with somebody with the idea it's not gonna last. Unfortunately, it doesn't always. And if you don't have a plan, the state of California is gonna impose one on you.
First of all, I'm very excited about this topic because I don't think it's talked about enough. It's kind of like all the GLP-1 now.
Yeah.
That everybody's going and buying all of these peptides online and not really even thinking about the adverse effects later. I have an education platform in real estate. And so one topic that comes up often are the trusts. And how does the trust help? And I know we most commonly think about death when we think of a trust, but people don't consider their LLCs going into trust. How does that work in the conflict resolution and some of the topics that you discussed today?
If if the trust instrument is good and is clear about what happens with the property, it's certainly helpful. Who deals with this the most out of the other partners? Carl?
Sure.
Real estate trust, so.
This never comes up. It comes up all the time, and in the estate planning side, you do plan for these things best you can, and so you try to decide. When I meet with clients, normally the mother and father, try to help them through imagining what is going to happen when one or both of them are deceased. And if you have a family business or you've got a lot of real estate holdings, sometimes they'll split the properties. They'll decide we're going to split the properties among the 3 children in this form. Because and I always try to suggest to them, if it's appropriate and they feel comfortable with it, talk to your kids ahead of time. Get their input about what their expectations are. And sometimes I found the best estate planners are the ones that are no surprises. Everybody knows what's coming, everybody understands what's happening. That doesn't occur all the time, but those have been the best approach when the time comes to implement the trust. Is everybody knows what's coming. They pretty much understand this is what mom and dad wanted. And the kids amongst them, normally mom and dad want to keep the kids happy. So they'll hopefully reach out to them and say, we want to make this work because the last thing we want to leave is a legacy of unhappiness in this family. And that seems to be the best thing that resonates with parents is this is not what I want to leave after I'm gone. That's kind of animosity.
But particularly
That's feeling.
if there's an uneven distribution on the trust, it's that can be hard to talk about, but really much better than having it be a surprise later. Because we also do a ton of litigation around that.
One is the lender, so he has the money, 2 has the property, the other's a banker. And one is gonna live in the property, they all have 3 families. And they're about to open an LLC and go into partnership together without even considering anything that you just discussed today.
I mean, they in that scenario, and it's always, this is why I like what I do, because they're all weird stories and facts and figuring out how the 3 families come together, and they're gonna figure out there are all these rights of possession that go with being in the house, so that complicates it. That's gonna give a leg up to that person, but are they paying rent or they're not? Do they have a maintenance obligation? Is there a number associated with that maintenance obligation? There's a lot to figure out in that scenario. It is ripe for later tension.
Jason,
Yes, sir.
very quickly, I'm glad there are people like Jason and Laura and other litigators at our firm, because I don't like what they do. And you do what you do. One takeaway also is vacation homes. When you want to leave it to the kids. And
Oh.
everybody has wonderful memories, and so we're gonna have them all each own it. It rarely works. And either the parents say it's just gonna get sold, or it's gonna go to one of them. That is a tough resolution. There is no easy answer on that one. And in family situations, and you probably have them also on the litigation side. Somebody may say, I don't even want this property.
Yeah.
But I don't want my brother Joe to have it, because once I get it, I'm just gonna sell it. But I don't like Joe so much, I just don't want him to have it.
Well, and so many things in the family cases that everything becomes a proxy for dad loved you better. I mean, there's a lot of that we gotta work through. And so it's the symbol of like, why didn't you get the vacation house? So these are tough things to take on.
So when you have, I've got a number of these situations going on, so do you suggest that one firm handle all of your transactions, let's say, because let's say I've got two partnerships and two small buildings. And then I've got, a couple of other residential properties. And so there's a whole mishmash of all this. And then I've got partnerships, but they're handled by different attorneys. So there's no communication.
Yeah.
So, one's not talking to the other. Would you suggest that all those come together? And, the attorneys that are maybe my age, that are mature, maybe aren't gonna stay in practice as when I need them. So what age attorney would be a good one to get?
Any age.
Like fine wine.
So typically, if the parties are the same in all of those entities, I would bring them together with one under one council, because the interrelationship among those properties and entities is maybe getting missed if you have different counsel for them. Now, it's important to know that counsel for the entity is not going to become your counsel later if there's a fight. They'll be out, right? If we're representing you as your transactional counsel for the whole partnership, we then can't take sides with one of the partners. But yeah, it feels super important for there to be sort of one person who understands the interrelationship of all the entities. And also can help you think about the structure and whether it makes sense. One of the things that in one of the cases I already talked about to you, where the properties have been frozen for 3 years. They read somewhere that's really important to hold real estate in LLCs. And now every property is in a different LLC, which can really make sense in terms of limiting liability and cross liability. But there's the most cockamamie, insane waterfall of ownership, including a trust at one point in the trust. And they messed up amending, so now they don't even actually own one of the properties, because there's a circular ownership where the trust beneficiary is an LLC, and the LLC is the member of the property, and there's no human being involved. So we can fix it, but that's costly. So I think it's really helpful to have one law firm working on it. In terms of the age of your counsel, ideally, I mean, if you're dealing with a solo, you got them for as long as you have them. If you're dealing with a firm, that's one of the advantages of being with a firm, is that there's a deep bench, so they can hand off.
Just one more piece to add on to that in terms of the advantage of having one lawyer handling multiple entities is you'll have consistency amongst those organizations. So you don't have to check what's a restriction on transfer for one and not another. It's time consuming. It's easy to make mistakes.
That's the other thing with the client I was just talking about. They were formed in 5 different jurisdictions, the entities, and it's not clear what law is to the case. So we're either gonna have to agree on that or have a court decide. That's adding cost to the whole litigation. So it would be,
Everybody has their own recipe.
yeah,
The consistency.
it's really important.
Yeah.
Yes.
In the time frame, if you're trying to do a partnership the right way and started off with a lawyer, how long does that usually take to put it together?
It depends on the complexity of the partnership and the business, but what?
If it's really simple, a couple weeks. If it's really complicated, a month plus. It really comes down to the negotiation. How granular do you want to get on the negotiations in the partnership agreement, operating agreement? You know, if it's formed, then it's formed, and we don't have to spend a bunch of time. If you want customized restrictions on transfers, sale, where's the money go on a sale of or a capital event, that kind of thing. Waterfalls, that all takes time.
How much you're agreeing in that process, but that might be really telling as well.
Back end, if you go to litigation and we see you, how long does that?
Mm.
I mean, like
Get comfortable, it's gonna last a while, so. I just set a trial in a case for, this is almost my entire practice, is partnership disputes. I just set a trial for March of 2028 that we filed back in the fall. So if you're in Superior Court, which is why you might want an arbitration provision, because that'll speed things up. There are pluses and minuses to that. But yeah, in Superior Court, they're setting trials somewhere between 15 months and 2 years. And, then the question is whether you go then, because often you have a trial date, but there are multiple people set for that trial date, and you may or may not actually get your trial then. So it's long.
Yeah.
Litigation, if it went all the way to trial, somewhere probably between 2 and 5 years. Fortunately, most things settle, 90-something% of cases settle. And that really comes down to the partner's appetite for the fight. Really, eventually somebody or both parties get worn out and we get to a resolution.
One of the things on the first part of that, when negotiating the documents, what you're paying for usually at that time. The ultimate document may not be maybe a relatively simple one, but what you're paying the lawyer to help you with is thinking about the things that you're not aware of. And you can make an intelligent choice about whether it's rights of first refusal or buyout provisions, governance situations where you would not think of them, but at least they're presented to you. You can then say yay or nay, and then you at least have considered these different things. It happens in all different kinds of documents, but in this one, really relevant because that's what you're paying for. You're paying for intelligent choices about how you want to operate.
And then you can make decisions about, you might just decide not to have every one of the provisions we ask you about in your partnership agreement because you decide the risk of that particular outcome is too remote to make it worthwhile. But at least it's been presented to you as partners and you've thought about it together.
Third question. So let's say you go to litigation and there's multiple assets in real estate. Are all of those assets frozen? No transaction can be sold?
Typically, yeah. So what you would see is probably somebody files a notice of pending litigation or what we used to call a lis pendens. So it's a staying untitled. They can't really do anything with the property during the pendency of the litigation unless you agree, which rarely happens, but sometimes people agree and then you escrow the funds, for example. We have not, in the case I keep talking about with the real estate, have not been able to agree on disposition of the property, so they're just sitting there. The other option is you could go to the court and ask the court to order it. You're probably not going to happen in most circumstances unless there's a real urgency. But that's one way to go. But yes, typically it's just sitting there while you have the fight. And may or may not be managed all that well because the managers aren't speaking to each other.
Like, what do you do in a situation where, like, say you've gone to litigation and you have a client who's either just, the relationship's broken down so much that they're not acting reasonable, they're advocating something that's just, you're saying you're completely in the wrong and they'd rather see both of them lose everything than the other person gain anything?
So if that's not uncommon early in the litigation where somebody really wants to burn it to the ground, the consideration for counsel is whether, overall you think that client is someone that will become reasonable and they're not asking you to do anything unethical, which sometimes happens. But usually part of a lawyer's job is helping work the client into a different understanding of the landscape. So that's part of what goes with it. If that goes on forever, there are times when you say like, listen, I can keep fighting this for you. I'll take your money for the rest of time, but this is not good for anybody and we need to go a different way. And usually, I don't know that I've ever had anyone who was like, nope, I don't care, burn it to the ground. At that point, I probably would suggest they move to different counsel, but I don't know, it would depend on the circumstance. Most people get somewhat reasonable. And I'm good at picking clients who are reasonable in the beginning, usually.
Jason used to be a litigator, so I'm recovering from it's health. But I found out very early on that the amount of litigants' principals is directly disproportionate to the amount of money they pay their attorneys. And so as those begin to, the amount rises, the principals come down, and right about here's where it settles.
Yeah.
Right? Everybody's equilibrium point's a little different. But most people will come to the realization that just spending money to make a point isn't always the best way to spend money.
And everybody's teasing the litigators, but let me say that it's a legitimate way to solve problems in our society that beats the old way. Get out there with guns and see who had the better aim. Yeah, so it works, and when you have sufficient assets at stake and you legitimately can't agree, and there are two different valid positions, it's a really productive and useful way to solve problems in our society. Unfortunately, it's also abused by a lot of people for reasons that aren't great. And so that's part of why it's so expensive and so slow.
Yeah, I'm a commercial real estate broker, and I see a lot of families that, maybe the father was a manufacturer or something like that. And he spends all this money sending his kids to college, and everybody becomes a doctor, a lawyer, whatever. And all of a sudden, nobody wants to do the job he was doing. So I guess that would be another good case for the annual meetings.
Yeah.
To figure out, okay, when's the time to figure out that exit strategy?
We see this a fair amount, where the subsequent generations don't really want anything to do with it. If they all agree on that, it's not so hard to unwind. If they disagree, that is where it gets complicated. And sometimes they won't want to run it, but they still want the business to be in the family and they want someone else to do it. Those are a little harder to figure out. And if there's sufficient assets there, they could, hire out the management and that can work, but that is tricky. Subsequent generations are some of the hardest things to deal with because there's a lot of all of that stuff involved. Family identity, feeling, and who dad loved best. But
Biggest concern is now everybody's wanting to get into multifamily. And that you have about 25 people non-syndicated that are going into this transaction. So I'm trying to educate myself on this because got a lot of business coming your way for if we don't get to the beginning.
So you actually just touched on an entirely separate issue, but whether the partnership runs afoul of the securities laws in having put it together, where investors are coming together who don't necessarily know each other, is a whole other set of complications. But it's the more stranger partners there are, the harder all this gets, in my experience.
Okay, well, I want to say big thank you. Thanks. Thank you, everybody. We actually got about 8 lawyers for the price of 1 this morning.
Yeah,
Thank
you
you
did.
very much to everybody at Hahn Hahn who came in, especially. I want to say thank you to Gloria Pack. She just snuck out, but if you see her, she was my partner in arranging all of this. So say a big thank you to her as well. Thank you for coming in. We are very interested in the partnership of knowing other topics that might be of interest to the community. I'll be reaching out again to the Chambers of Commerce. All of you, please feel free. You should all have my email and phone number from the last few weeks. Let us know what you want to hear about. Hahn Hahn is a huge resource, and we'd love to tap into them again. All right, so thank you very much.
Anytime.
Thank you.
We're big fans of the partnership.